Welcome to In Focus with Silvana Pavlovska. As part of our series dedicated to the Macedonian question, we are continuing the Prespa Agreement as cultural genocide of the Macedonian national identity towards the termination of an illegal treaty, a scholarly publication by Prof.d-r Igor Janev, which was published late last year. We are still on chapter 4, and we shall continue it as follows. In my recent analysis, says the professor, it has been shown that the easiest way to terminate the Prespa Agreement is invoking of a simple fact that the second party being the Macedonian state of the Prespa Agreement, as indicated in the UNSC Resolution 817 from 1993, as a nameless state or a nameless one, does not actually represent a valid ID, doesn't represent a valid ID in the contracting process. Unlike the first party, that is the Hellenic state, that was additionally defined as the Hellenic Republic, in the Prespa Agreement, the second party couldn't be identified since its name was implicitly derived from the UNSC Resolution 817. And actually that was the whole idea of the Resolution 817, not to have a name in the UN. For temporary denomination, the FIREM is designated only for the purposes of the representation in the UN system. As we explained earlier in our previous broadcasts, this additional United Nations condition, a denomination, was an illegal one. And from illegal institution, there is a fake name, law may not be invoked or created since the ex injuria jus non oritur. In the UN Security Council resolution 817 from 1993, there is invocation of the application letter with the number S25147, avoiding any legal or constitutional identity or state's name for a purpose not to recognize it. And as we have explained previously, provisional denomination is therefore not a part of the state's judicial personality, since the name, according to the regime of Resolution 817, yet had to be defined with the other state via negotiations. And therefore, the nomination, the provisional, the FIREM one, could not be used for agreements outside the scope of the UN or erga omnes. Clearly, the Prespa Agreement was signed as erga omnes act, that is, outside the scope of the United Nations. And in the moment of the signing, it was improper for drafters, or those who drafted the document, to directly use the UN denomination, that is the FIREM, as it was subject to replacement, or the current constitutional name, Republic of Macedonia, that had to be changed and ignored. So people who drafted the Prespa Agreement try to avoid both names, but implicitly use provisional reference by invoking designation in Resolution 8117, proposing admission to the UNGA of provisional limited character, wrongfully embedded in the troublesome recommendation of the UN Security Council Resolution 817. At that point, the legal experts didn't realize the limited character of the so-called provisional name, which actually does not constitute an element of the judicial personality as unrecognized domestically by Macedonia, and may not be used out of the UN system for bilateral relations, especially not with erga omnes feature. Greece was the first country in bilateral diplomacy where Macedonia has been obliged to use the provisional and therefore illegal denomination for contracting as an imposed description designation for that state. But that doesn't make it legal. For that reason, since the denomination, provisional or permanent, or mere reference pointing to denomination in the Prespa agreement invoking it, cannot be considered as the valid ID of the sovereign entity. Prespa agreement should not be considered a valid treaty on technical grounds. Namely, in this bilateral agreement, the Prespa agreement, we do not have an identity of one contracting party in the contract or the agreement. Therefore, the nameless or the ID-less, without an ID, agreement is by definition null and void, since it is based on the illegal reference or denomination of Macedonian admission to the UN, along with the second illegal condition, which is the negotiation with the state that didn't recognize the national identity over the state's name. Since the Prespa agreement is registered in the United Nations with its legal effects exposed, it is necessary to send a diplomatic note to the government of the Hellenic Republic on unilateral termination of an invalid treaty, and a note to the UN that the Prespa agreement was terminated due to all facts discussed in this chapter above with respect to jus cogens norms. From the theoretical and practical point of view, there is a matter that should be examined in detail. From the period of the start of the negotiations on the name issue in 1993 to the very end in June 2018, the state's name negotiations were unsuccessful, since the Greek government insisted that the new ID for Macedonia must be used for all legal systems, not only as an international designation, but domestically in Macedonia too. Greeks knew that the state's name is legally defined by the constitution, and that only by changing the constitutional name, that is the constitution, they will succeed in the state's name redefinition. For the Macedonian government, the constitutional change was not an option until 2018. What was unknown to the Macedonian public, that is the politicians, the scholars, the diplomats, and so on, was that the state's name is the primary and essential national and legal element of the judicial personality of that state, both domestic and international, as a sovereign, domestic, and international legal subject person with sovereign identity, and that judicial personality as such is the inviolable, most essential substantive element of the statehood. All Macedonian governments and presidents waited for so long in time in false hope or delusional fallacy that one day a compromise solution will be the Republic of Macedonia for domestic use only and some other name for international use. This myth and misconception that two names may exist combine was a main reason for inability to solve the problem for such a long time. Actually, in the absence of the knowledge that such problems do not have rational and legal solutions, the Macedonian diplomats waited in hope that the problem will vanish by itself and that erga omnes was not an option. Namely, the state's name as defined by constitutional name is the most substantive and unique element of the judicial personality as a whole, with a unique ID, erga omnes, and for that reason and the principle inviolability of the judicial personality, including its substantive elements such as the ID, the constitutional name, that is the state's name, is the only legal ID for international and domestic contracting. The executive branch of the government is not authorized in any country to change the state's name alone without prior consent of the parliament and of the people, especially for contracting any particular treaty. And in principle, the state's name or ID is erga omnes for all official representation and legal operations, both in the domestic and international legal systems. The state's name as an ID belonging to the sovereign judicial personality of a state as the sovereign subject is the only and a unique legal identification provided in the Constitution for international public legal operation or contracting or representation where foreign interference is not legally allowed. Otherwise, or conversely, if the designation or name is not part of the judicial personality that is per se inviolable with prerequisite of non-interference, such not natural and therefore external name may not serve as the ID for a state, since the ID must be part of the set of rights belonging to the inviolable judicial personality, and since only an independent legal capacity of the judicial person provides for sovereign contracting or legal representation or any other public legal business. When provisional denomination, that is the FIROM, was imposed by the UN organs, Macedonian state didn't lose its constitutional name, and that official name was used to establish diplomatic relations with more than 130 members of the UN by bilateral agreements with constitutional ID. It should also be noted that more than 135 states have recognized Macedonia under the name Republic of Macedonia until the name was officially changed by the Macedonians in 2019 with constitutional amendments in accordance with the Prespa Agreement. Taking all this into consideration and what we previously concluded, we could generalize that only the constitutional name could be part of inviolable, indivisible judicial personality, and that legally the state's name could serve as ID for all international and domestic public legal operations, unless otherwise provided by constitutional law and the people's will. In conclusion, the United Nations organs may not redefine the state's name, since constitutional name designates the ID of the state as internal matter with inalienable and inviolable basic legal element contained in the judicial personality, and only the legal personality provides the proper legal capacity in the form of entitlement to contract and operate internationally. The legal ID for internal personality and international personality are by definition same name, one that is unique. Imposed names or denominations or designations are not part of the sovereign judicial personality. That is, that includes inalienability and inviolability of sovereign legal ID as defining substantive inherent part of that indivisible personality, and only that ID represents a valid contracting ID. The FIROM apparently represents illegal and therefore a fake representation or misrepresentation of the member state in the UN, where the organization made Macedonia to carry wrongful, false representation. So, the Macedonian legal ID, which is the state's name, was all the time in their Macedonian background, he says. And before they renamed themselves by the constitutional changes, or through the constitutional changes, they, through the cunning and deceitful international treaty, avoiding the legal ID for the second party, international community could not change the domestic name of a country by its acts or decisions. If, for instance, Macedonia had never joined the United Nations, this country would presently still be the Republic of Macedonia, without any obligation to negotiate or revise its official state's name under foreign interference. In fact, any moral statesman with dignity, when confronted with a dilemma, in quotation, to join the United Nations with provisional designation or abandon it, end of quote, would rather withdraw the application for the UN membership. They would withdraw that application for the UN membership, then be humiliated to negotiate the national name with the country that didn't recognize the national applicant's identity and its basic rights to self-determination and sovereignty, including the basic human rights of the people. As we've already explained in this publication, the Macedonian leaders repeated the same mistake again and again by admitting or confessing that they were in a dispute with a neighbor in the case of Greece, not just once, twice, in 1993 and then again in 1995, and then with Bulgaria in 2017, and later when actually they started the negotiation over the so-called historical issues. As we have seen here, a dispute with Bulgaria already produced a set of actual compromises on all for historical relevant, I beg your pardon, for historical relevant Macedonian persons, that were with consent, they declared that the Bulgarians, they were Bulgarians according to interpretation by the Bulgarian government. Chronologically up to the 20th century, that is until Macedonian hero Goce Delcev was the last relevant individual to be proclaimed as Bulgarian. And from that moment, as it appears, the game with Bulgaria could not go further. The fact that the Macedonian international institutions did not respect the will of the people, and specifically Western international community, made the PA, the Prespa Agreement, possible. The Western community that invested so much in the Prespa Agreement didn't understand the concept of people's sovereignty arising from the sovereign citizens or nationals and inherent moral dignity, and put pressure for direct violation of the Constitution and redefinition of the state's legal identity, inherently related to the national dignity, a sovereign and independent will of the citizens and the people, and their right to self-determination as a basic, inalienable right. The right to self-identification of every national group is related to the inherent independent right to the state's self-determination, free choice of the name that is unbreakably linked to the state's and people's dignity, protection of moral standards, and the basic elements of the statehood, its judicial personality. As we mentioned previously, the concept of the United Nations and the UN Charter is based on people's sovereignty and self-determination with no interference. That is, the right of the people to self-define themselves in dignity as an absolute free choice, including determination of its own cultural identity based on respect to their original beliefs and traditions or history. Therefore, according to some authors, we may derive the following principles of law. 1. No external regulation or act adopted outside the state itself can determine, create, impose, or abolish the state's legal identity and the constitutional or national name of the nation state. 2. No external regulation or act adopted outside the state can determine, create, impose, or abolish the national or national collective identity, which is subject to self-determination. If we apply here the presented principles in the Macedonian case, we can only make a conclusion that all negotiating framework defined by the UNSC Resolution 817 from 1993 and supported by the UN Security Council Resolution 845 from 1993 was an illegal one. This is a simple conclusion. This simple conclusion follows from the fact that any legal outcome in the form of act or compromise would necessarily violate the basic principles of the international law, including the jus cogens norms such as self-determination, non-interference, and judicial equality or sovereign equality of member states in the United Nations. Most of the UN members foreseen such absurd result and unilaterally recognized the FYROM as the Republic of Macedonia, with no observance for limitation provided by the Security Council Resolution 817. Just before the Macedonians renamed themselves, it appears that over 140 states have recognized it as the Republic of Macedonia, although the Macedonian diplomats never lobbied and requested them to do so. For the majority of the UN member states, the difference over the name was never the security issue. Unfortunately, it seems that Macedonia was the only member in the international community that didn't understand that. So they kept negotiating on the issue to the very end with regard to the Prespa Agreement. After the United Nations Security Council Resolution 845 from 1993, there were no other Security Council resolutions or meetings or acts demanding negotiations with the two states. By that fact solely, it was actually demonstrated that the problem between the two countries was not one of a security nature. And as we can derive from the nature of the UNSC Resolution 845, 1993 as a recommendation to the UNGA, it was never the security issue, even from the very start of the process, as we explained with respect to Resolution 817 of 1993 and the creation of an irrational negotiating framework. It should also be noticed that the so-called security issue never actually ended in the Security Council after the PA or by any Security Council resolution dealing with issues, as was usual practice for conflicts or disputes regarding Security Council decisions. There was only a simple notice sent to the UNGA that a difference was resolved between the parties. All affairs about the name issue finally ended by ordinary registration of the treaty in the UN Secretariat with no reference to security aspects. From the judgment of the International Court of Justice, ICJ 2011, we also learned that the alleged irredentism accusations against Macedonian state were actually rejected or ignored by this court in its proceedings. Namely, the International Court of Justice in its proceedings proved that all accusations against Macedonia were legally groundless. Still, most Macedonian diplomats today still believe that the name issue had the security character, demonstrating lack of knowledge, of course. What I found, says Professor Igor Janev, what I found strikingly important for the outcome with the PA was that in general, the political culture in Macedonia was very low, since people basically didn't understand the problem and blamed the foreign powers. And on the other hand, politicians in their ignorance rarely suspected the bad intentions coming from Western partners and even Greece. Finally, at the end of our discussion in this publication, Professor Igor Janev says, I will try to predict the possible outcome for national destiny and consequences of the Prespa Agreement, including the magnitude of damages for the state and the regional security. Instead of bringing peace in the region, the Prespa Agreement served as a ground for destabilizing the relation with Bulgaria, giving a bad example with the Prespa Agreement how through an ID treaty state can accomplish their interests. By creating a dispute and a treaty such as the Bulgarian Friendship Treaty from 2017, blackmails and conditioning could either create a new ID treaty for redefinition of history, language, or more likely tear down bilateral relations, the level of threats with military intervention, as we have seen from the statements of the Bulgarian Minister Karakachanov. The Bulgarian Friendship Treaty served as legal basis for illegal conditioning regarding the imposition of the Bulgarian truth and one-sided interpretations that all Macedonians were Bulgarians and that Macedonians need to learn the truth before Macedonia starts the process with the EU for admission. The leader of the opposition, Hristijan Mickovski, with respect to the Bulgarian treaty, stated that this treaty created only problems. We quote, Zaev can't continue to hide from the public and avoid revealing what is being negotiated. He needs to go before the press and inform the citizens about the new additions that Sofia demands are made part of the EU accession process. In a similar context, a leading party member of VMRO-DPMNE, I. Dimovski, declared that the PA led to the dispute with Bulgaria, namely Zaev's Prespa Treaty with Greece and the redefining of the Macedonian national identity contained in it opened the door for Bulgarian politicians to condition Macedonia, and in addition, quote, pointed to the admission that Zaev that former Bulgarian Prime Minister Borisov was himself involved in the preparation of the Prespa Treaty, so that, quote, the Prespa Treaty redefines the Macedonian national identity and bans us from evoking the Macedonian timeless civilization heritage. There is no similar treaty in Europe that would have two countries define what it means when I say that I feel as a Macedonian. What is the meaning of the word on the different sides of the border? Now Bulgaria wants a similar redefining of the Macedonian identity. The ultimate goal of both Bulgaria and Greece is to downgrade the Macedonian national, ethnic, and linguistic identity. Even from the beginning of the process in 2020, Hristijan Mickovski from the opposition party gave his statement that the Bulgarian treaty needed to be renegotiated. Quote, I will ask for a clear declaration that we will not negotiate on the uniqueness of the Macedonian language, identity, and history. And if Bulgaria continues to demand these concessions for us, the treaty with Bulgaria will be dead. Mickovski also stated that, quote, artificial nations and rootless trees wither and die, end of quote, and added in conclusion, quote, if we break this link in the chain of our existence, we break our continuity. If we give up the partisans, we will give up the Ilinden Committee, and if we give them up, we will also give up on a century of our struggle for liberation. What will we have left then? End of quote. Just a reminder, you're listening to In Focus with Silvana Pavlovska, and the topic is the Prespa Agreement as Cultural Genocide of the Macedonian National Identity, a scholarly publication by Prof.d-r Igor Janev, who's an expert on international law. And I thank you for your attention and look forward to seeing you again soon. Bye for now.